Well, welcome everybody to this evening's event, Supporting Distressed Businesses in the COVID-19 Crisis, the view from the UK. We have a fantastic lineup of very eminent speakers, and I'm going to introduce them properly in a moment. But before we do that, I just wanted to offer some introductory remarks that will hopefully contextualize their presentations and the discussion that is going to follow. I should preface my remarks with a reminder that we are recording the proceedings today, and we'll publish the recording online after the event. Well, today's talk is one in a series on the subject of how states are responding, how governments are responding to an anticipated wave of business bankruptcies associated with COVID-19 trading disruption. The first event in the series, which was chaired by Horst, one of our panelists today, was on the policy response by the German state. And tonight we're going to look at the UK policy response to financially distressed businesses who've become distressed during the COVID-19 pandemic. And this series of talks is part of a broader project called the COVID-19 Public Policy and Commercial Law Project, which I'm doing with my colleagues, Professor Oren Sussman and Professor Horst Adenmuller, both at the University of Oxford, a project that's funded by the university's COVID-19 Research Response Fund. The motivation for this project is the practical recognition that absent intervention by governments, we can expect mass business bankruptcies to follow any significant period of trading shutdown in an economy. And what we observed as the COVID-19 pandemic progressed at the beginning of last calendar year was policymakers moving with remarkable speed to assist in response to an anticipated wave of business bankruptcies, experimenting with things like subsidies, outright cash grants, interventions in contract law, and the suspension of pre-pandemic insolvency rules. It also seemed to us that it was not always clear why states had intervened in the way they had and at the time that they had. So in this project, we're interested in understanding this policy response, how and why policymakers intervened, and with what effects. And we're particularly interested in the long-run effects of these policy interventions, including the long-run effects on pre-pandemic commercial law. The grounding intuitions for the project, I think it's fair to say, are the following. First, our intuition at the start of this project was that bankruptcy law was not likely to be a good candidate for the treatment of COVID-19 induced financial distress. We thought bankruptcy law was a poor candidate for treating this distress. At the same time, we acknowledged that states faced very hard choices indeed in designing alternative routes to relief for financially distressed debtors if the pre-pandemic bankruptcy or insolvency law was not to be used. And I think what we're going to hear about the UK policy response today is going to demonstrate some of the complexity and difficulty around the design of this kind of alternative to bankruptcy policy response. So I said today we're going to focus on the UK. As all of you will be aware, I'm sure the UK is among the most severely affected jurisdictions by the pandemic, both in terms of health indicators and economic indicators relatedly. So you can see on the slide this lovely diagram, a graph from the Institute for Government, which seeks to relate the scale of the impact to the economy to previous crises. And you'll see you have to stretch back in time to the Great Frost of 1709 to get something equivalent in terms of what is expected to be the hit to GDP for the UK economy last year. In terms of impact on business turnover, and we would expect that decline in turnover is going to, in many cases, be a trigger for becoming cash flow insolvent with knock-on effects for businesses. There's a lot of very interesting data around the impact on business turnover during the series of UK lockdowns that we've seen in the last 11 months or so. And this is just one piece of evidence on turnover. This is from the Office for National Statistics, and it shows the impact on business turnover between June and December last calendar year. So the top line is businesses reporting a decrease in turnover. And you can see in June last year, about 65% of businesses, a really staggering number, proportion, are reporting a decrease in turnover. So that line declines as the graph progresses towards December. But even in December, over 40% of businesses are reporting decreased turnover. And of course, this is prior to the imposition of the most recent set of national lockdowns. So what we would expect, I think, looking at this data is lots and lots of cases of business bankruptcy, lots of filings for collective insolvency procedures under UK insolvency law. But of course, we haven't seen that. So the Insolvency Service publishes a very helpful statistical bulletin periodically, and this is an extract from the most recent bulletin in which the Insolvency Service has this to say about England and Wales, which is what we're primarily going to focus on today. Overall numbers of company and individual insolvencies have remained low, reports the Insolvency Service, since March, when the first lockdown was imposed. So if you compare rates of insolvencies now with comparable periods in previous years, rates remain low. And this is attributed by the Insolvency Service to two factors. First, legal temporary changes to the insolvency regime that made it harder to compel the commencement of liquidation. And secondly, what the Insolvency Service terms enhanced government financial support for companies and individuals. We're going to focus primarily on the corporate response today. So this slide gives you a little taste of the complexity of what the Insolvency Service is terming this package of government relief. So the starting point, as the Insolvency Service suggests, is to acknowledge that Parliament moved quickly to dilute direct triggers for the commencement of insolvency proceedings, and more specifically, compulsory liquidation. And the government also temporarily suspended, or the so-called suspension of the wrongful trading rule, which might be characterised as a dilution of an indirect trigger for the commencement of insolvency proceedings. At the same time, the government offered a battery, if you like, of packages of relief to businesses that were or might be expected to be distressed. And I've listed just some of these on the slide from a range of sources. So landlord remedies were restricted, businesses were offered rates relief, businesses were offered subsidies in a range of sectors, and a non-trivial amount of cash grants have been offered additionally to a range of businesses, particularly at the smaller end in a range of sectors. Trade credit reinsurance program, the assumption of wages in a furlough scheme, along with a complementary scheme for the self-employed, the offer to businesses to defer the payment of already due taxes, new loans that were state-backed or state-issued, and new state-backed convertible loans. So how much is this all going to cost? Well, we don't know yet exactly, but there are some initial indicators. So in relation to rates relief, this is predicted to cost the government £10 billion. The well-known Eat Out to Help Out scheme, which was a subsidy for hospitality, cost, according to the National Audit Office, £522 million. And the furlough scheme, as at December, had cost the state £46 billion. In addition, the tax deferral and loan schemes are expected to cost the state significantly, because it's widely thought that a bundle of claims that are affected by these schemes are not going to be paid, such that in the end, they'll have to be written down or restructured. So far, this story for the UK looks a little bit like the story we conceived when we started this project. We thought bankruptcy law was not going to be a good candidate for the treatment of COVID-related financial distress. And at the same time, we recognize that if states didn't use insolvency law, they'd have to do a lot of other things to try to offer relief from that distress. The complexity or wrinkle for the UK is that the government also did something else. and that's to permanently, in a non-trivial way, change pre-pandemic insolvency law. So what we have seen, in addition to the dilution of triggers for entry, keeping businesses out of pre-pandemic insolvency law, and offering relief in a number of other ways, we've also seen that states substantially amend pre-pandemic insolvency law in a series of changes that I would suggest are fairly characterized as seismic, and that we haven't really seen the likes of since perhaps the Enterprise Act or the Insolvency Act of 1986. So today, our three speakers are going to look at parts of this story, each with a different point of emphasis. Our first speaker is Felicity Tobe, QC of South Square. Felicity is a well-known, eminent insolvency silk who has been awarded Insolvency Silk of the Year too many years, I think, to count. Felicity, thank you very much for being here. Next, we'll hear from Philip Hertz, who's head of the restructuring practice at the very large, well-known law firm Clifford Chance. And then finally, we're going to hear from our academic speaker, Professor Sarah Patterson from the London School of Economics, who is that rare thing, someone who is both an academic and someone who had a very long career in practice. So we're very grateful indeed to Sarah for being willing to speak today as well. So over to you, Felicity, for the first of the three talks.
Well, I'm the failure on the panel because I have failed to do any slides. And that's partly because I find the whole subject of the way in which directors' duties have been addressed by the government a bit too depressing to put down on paper. And so I've been asked to think in particular about those directors' duties and the way in which they've been dealt with since the pandemic. And I have the grand total of about 10 minutes to get through the areas. So some of it's going to be a bit high level, and I suspect we'll come back to a bit of it later. Now, I was reminded in preparing for my little talk today that not all of those of you who are listening spend all their waking hours thinking about insolvency, and in my case, also my sleeping hours. And so I was asked to start perhaps with some of the basics and then go on to explain or possibly rant about what the government has done in relation to them. So in order to do that, I propose to spend a few minutes just running through the sorts of liabilities that a director might be subject to in the veil of insolvency. So when an insolvency is coming along. Then I'm going to talk about what the government could have done. Then I'm going to talk about what the government did do. And then I'm going to say a little something about the oddities of what the government then did. As I say, it's probably that latter point that we'll come back to discussing. Now, I'm going to assume, for the purposes of my remarks, that we're dealing with English directors of an English company. I could also say Welsh. I won't say Scottish because I don't know enough about Scottish law, and everything has very odd Latin terms, so I will inevitably get it wrong. So starting then with the sort of liabilities that a director might owe. As we know, as a basic principle, when a company is trading solvently, the directors owe duties to the stakeholders who are essentially the shareholders. And those duties are expressed as a duty to act in a way that the director considers in good faith would be most likely to promote the success of the company for the business and its business for the benefit of its members as a whole. Now, of course, in contrast, we know that when a company finds itself in financial distress, and that's a phrase which we'll be coming back to in a different context, but for present purposes, I'm going to say that means either insolvent or likely to become insolvent, in the sense that insolvency is probable. There is a shift in the focus to the interests of the creditors. So the directors now have to have regard to the interests of the creditors. We sometimes call this West Mercia, we could call it Sequana. And when a company is actually insolvent, of course, the interests of the creditors are paramount. Now, let's leave aside this interesting question about when one shifts from one of those to the other one of those, and let's assume that we're just in some sort of position where directors owe obligations to consider the interests of creditors in some sort of way. What sort of claims might there be against directors if they do something they shouldn't be doing during this time? Essentially, there are four of them. There's wrongful trading, there's fraudulent trading, there's misfeasance or breach of duty, and then there are disqualification and compensation claims. So those are our four main headings. Starting with wrongful trading, that bites when a company's gone into administration or liquidation. It can be bought by an office holder or their employee, their assignee. And insolvent means effectively the balance sheet or cash flow insolvency. When does it bite? If a director knew or ought to have concluded that there was no reasonable prospect of the company avoiding an insolvent administration or liquidation. Some people call that the critical moment, but I'm just going to call it the relevant time for a minute. Who can you bring a claim against? A de jure, a de facto, or a shadow director? And what sort of knowledge does somebody have to have? It's a mix of objective and subjective. What's the remedy? It's a civil liability remedy. And the courts have come to the conclusion, at least recently, that it has to be an increase in the deficit to the company. What are the defenses? You can't make an order against a director or a shadow director where from the relevant time that person took every step with a view to minimizing the potential loss to the company's creditors as they ought to have taken. So let's just bear that in mind when we come back to what the government's done. Second class fraudulent trading, again, applies in administration or liquidation, can be brought by an office holder or their assignee. Insolvency, same as wrongful trading. When does it bite? If it appears that any business of the company is being carried on with the intent to defraud creditors of the company or creditors of any other person, which has always been an interesting one, or for any fraudulent purpose. Who can you bring a claim against? Not just directors, but also anyone who's participating. What sort of knowledge, dishonesty, but also including deliberately closing your eyes. And what about a remedy? This is a contribution remedy and it's not limited to loss. Third sort, misfeasance. Misfeasance doesn't sound like it's got to be anything different from the others, but it can actually also include negligence. So it can be basically any form of breach of fiduciary duty, and can either be brought as a breach of duty claim or can be brought under Section 212 of the Insolvency Act. When does it bite? It bites on any past or present officer of the company, which is wider than directors, who's misapplied, retained, become accountable for any money or any other property of the company, or been guilty of any misfeasance or breach of fiduciary or any other duty. So it's very wide. What's the remedy? Pretty much anything the court thinks is appropriate, repaying, etc. What are defences, apart from I didn't do it, acting honestly and reasonably. Then you've got your fourth lot, which are disqualification and compensation orders. And those are brought by the Secretary of State, and they allow anyone who is unfit to be disqualified for between 2 and 15 years. When is it insolvent? Pretty much any liquidation, administration, or administrative receivership. Now, this is, as I've said, a disqualification between 2 and 15 years, but there can also be compensation orders. So with that incredibly swift romp through those 4 categories, what you notice is that there are 4 categories of them. There isn't just one, it isn't just wrongful trading. The other thing you notice is that there are all sorts of defences to this. And the defences involve basically acting reasonably, acting honestly, and in the context of wrongful trading, whether you ought to have known about what might happen to the company. So what did the government do about these duties? Well, before we look at what they did do, what could they have done? Well, first of all, they could have done nothing. And they could have done nothing because, as I say, all of these things have built into them the sorts of defences that you might want to use if you were in the middle of a pandemic. So as I, for instance, don't know whether my children are going back to school in 2 weeks or 3 weeks or 4 weeks, or when I might be able to take a holiday, or when the courts might open, you might think if you were running a company, there might be all sorts of reasonable excuses for whatever you might do, as long as you're acting honestly and reasonably. And so it seems actually tremendously unlikely that there would be any sort of liability for people who are acting honestly and reasonably. Alternatively, the government could have suspended all of these liabilities, or at least the ones which weren't just common law liabilities. Now, what did the government do? Well, it suspended, or not quite suspended, but we call it suspended, wrongful trading. weirdly, it suspended it from the 1st of March to the 30th of September. During that time, everybody in the universe said, this is not a good idea. There are all sorts of other liabilities which are out there. Why have you suspended wrongful trading? That doesn't make any sense. And then at the end of September, it wasn't extended. And everybody thought, of course, that makes perfect sense. Then the government reintroduced it on the 26th of November. I have no idea why they did this, nor do I know what happens to people who were trading between the 30th of September and the 26th of November, because it's not retrospective. Very briefly, given the time, what did the government think it was doing? It thought, it says in the explanatory notes, that it was getting rid of the personal liability for wrongful trading from directors who try to keep their companies afloat through the COVID-19 emergency. Okay, well, that's perfectly laudable, but why did they think this was the way to do it? And they dealt specifically, again, in the explanatory notes with wrongful trading and said, oh, well, the threat of a possible future liquidator or administrator making a wrongful trading application is a strong deterrent to directors, causing a company to continue to trade where there's a threat of insolvency, even if they intend to take steps to minimize losses to creditors. Well, I don't think that's right. I don't actually think it really is a strong deterrent. And I don't think it would have been a strong deterrent in the context of a pandemic. Then the government says the current crisis caused by the COVID-19 pandemic means there's a great deal of uncertainty around trading conditions in both the immediate and longer term future. Well, that's true. But why is the only thing that is impacted by that wrongful trading as opposed to the other three categories? Then they say, well, the objective of the measure is to remove the deterrent. So having decided there's a deterrent, they want to remove it. This will help to prevent businesses which would be viable but for the impact of the pandemic from closing. Well, I'm not sure that makes any sense at all, because if businesses would have been viable but for the impact of the pandemic, they're probably not in wrongful trading category anyhow, because they're not in new or ought to have known universe. But in any event, even if they are in the right category, then they're in the right category for everything else as well. Probably not fraudulent trading, because somebody's probably not dishonest. So the government then goes on to analyze the risks and say, oh, well, yes, okay, it's a bit of a risk that people might act in a cavalier manner. They might be encouraged by the suspension of wrongful trading to act in a cavalier manner. Well, I don't believe that that's right, because certainly if they wanted to use the honest and reasonable defense in relation to breaches of duty, they'd have to continue to do that. But the government thought that this might increase the risk of reckless behavior. And they said, well, you might think that this might impact badly on creditors, but they said, no, well, we think the increase in risk to creditors is very small compared to the support provided to the businesses. But again, how does that make any sense? It's either a risk or it isn't a risk. It doesn't seem to me that this balancing of the risks to the creditors actually makes any sense. And in fact, one of the things the government said was that, well, you don't need to worry about these risks because other protections still exist in company law, insolvency law, and enforcement regimes. So they said, we can suspend wrongful trading because there are other categories of risk that the directors are already subject to. So it's not as if they didn't know the answer to this. And it's also particularly odd because it contrasts with the approach taken by the government in relation to directors' liability during a moratorium under A1. So the new moratorium talks about whether or not there should have been a suspension of director liability. And there was a lot of argument over that. And the government originally planned to suspend directors' liability for wrongful trading during moratoriums and decided not to. So it's a very, very strange thing for the government to have done and a very inconsistent thing for the government to have done. And having done it once and not extended it, it's even stranger that it reintroduced it. So I think that probably is the end of my particular rant on this, but I am confused, I should say, by this particular version of suspension.
Thank you very much, Felicity, for that talk. And at the end of the presentations, I will ask Sarah and Philip to give us their reaction, to the extent it's not already covered by your presentations, to the so-called suspension of the wrongful trading rule. And before handing over to Philip for his brief talk, I just remind audience members that there is a Q&A function that you can use to post questions, which I will keep an eye on during the presentations and put to the panelists at the end of the presentations. Thanks again, Felicity. There are lots of things I would like to say. I will say them at the end and hand over to Philip now.
Okay, thanks, Christian. I'm now going to show my ineptitude technologically, even put my teeth in to try and share my screen. Which there you go. Hold on. Can everyone see that?
Not yet.
Great. There you go.
Yes, that's working.
That's working. You can
But
see that.
We can't see the slides yet.
Okay, so where? Oh, that's right.
It's more of I think, a desktop view.
It's weird. Okay, so I try. Sorry, everyone.
It's okay. Take your time. Yep, that's perfect. You just need to
great.
go into the slideshow mode.
Right, there you go. Thank you. Instructions for the technically inept. There you go. From beginning. There you go. Right. Now I'm going to try and look at the camera and follow the slides as well. But can you? So you can see the slides, yeah. Look. Good evening, everyone. I thank Kristen for inviting me to do this talk. It's interesting. It's something I've been thinking about for a while, in the sense of, why did the government introduce what it did when it did? And whereas Felicity's taken the temporary measures, I'm going to be looking at the permanent measures introduced by SIGA. And I mean, there were three of those. There was a standalone moratorium, the prohibition on insolvency termination clause, otherwise dealing with the so-called ipso facto rule, and then the famous restructuring plans. And I'm really going to focus actually on restructuring plans, because I feel like that's a little bit like Felicity. That seems to be encompassing my days and nights and weekends. And I think that, these three measures, I looked and thought a little bit more. I mean, it's much more than an emergency response to COVID, frankly. I mean, I've always thought, and I remember years and years and years ago, the government eyeing Chapter 11 across the pond quite jealously, and never quite having a procedure that could rival it or deal with it. And added to that, then after the directive on preventative restructuring, the impending introduction of the so-called super scheme of arrangement in the Netherlands, and now the German equivalent. It felt as if, and we had our my Amsterdam based partners sort of laughing a little bit of us, saying, you've got the scheme of arrangement, but we've got this super scheme, haha. Except we seem to have come up on the inside rail very, very quickly and got there first. And COVID seemed to be the excuse. Although, I mean, it was slightly odd, because it wasn't as if all of a sudden restructuring plans would be the answer to everyone's prayers, or maybe lawyers, but not many other people, I would imagine. And so these are actually permanent reforms, with and which will sit on the statute books, and they are pretty fundamental, as I think, as Christian was saying. Someone said they're the most fundamental changes for 30 years, and thinking, blimey, that was almost when I joined Clifford Chance back in '91. So it's been a long time. What I plan to do is focus on restructuring plans, really, and their primary aim is to support distressed companies. And I want to talk about some of the key conditions and features, and what have the cases so far taught us, if anything. So just to move on, is that I'm just now I can see the overview. Is that can you see the coloured slide,
Yes, we can see the coloured slide.
Oh, you can see it. Fine. Okay. Fine. Okay. This is. I'll just skip through this. This just shows where schemes and restructuring plans sit. Really in the pantheon of procedures. They're not insolvency procedures as we as necessarily as well. Certainly schemes aren't as we traditionally understand them, because they sit in both procedures sit in the Companies Act. My dog's agreeing with me. Thank you. At least someone in the house does. But the traditional insolvency procedures, you had administration, liquidation, CVAs, and then on the other side you have security enforcement measures, and these sort of sit in the middle as kind of pre-liquidation restructuring processes. As we'll discuss, there is a little bit. I mean, there's a lot of debates going on in various spheres as to where restructuring plans really sit, as to whether what are they insolvency processes, are they not, and there are different people arguing those whether they're not for different reasons. So just to move on, looking at can you see that screen? Sorry, so can you see key conditions and features? So because on the screen I'm looking at, all I can see is my overview still. So I don't know where.
Yes,
I don't know.
key conditions and features.
Oh, fine. Okay. So very briefly, look, we at the moment, I mean, everyone knows. Well, most people will know that we have this tool called the scheme of arrangement, which a company can propose to its creditors or any class of them. It's the most powerful 2 paragraphs in the Companies Act, probably, because it can be any deal that is agreed, as long as 75% in value, majority in number in a scheme's context agrees, and the court sanctions the plan, a scheme. That is a deal, and you can compromise, and it's particularly useful where you need to compromise bond issuances or facility agreements where ordinarily you would need 100% consent. So moving on, and that allows what I've always called horizontal cram down across tranches, and you can target it to apply for particular debt. Moving now to restructuring plans, they look to adopt many of the features of schemes, in the sense that they sit in the Companies Act. They're implementable between companies and classes. They go through a similar procedure, but they have some very different features. First of all, there are conditions of entry. There have to be financial difficulty. The company has to be suffering financial difficulties. The restructuring plan needs to be a compromise for the purpose of actually eliminating, reducing, or preventing or mitigating those financial difficulties. So there's some entry conditions. There still needs to be, as we say, for the compromise conditions, some give and take. But unlike schemes, restructuring plans need those 2 entry requirements. The jurisdiction of the court is pretty much the same for restructuring plans as they are for schemes. We used to joke about the long arm jurisdiction of the bankruptcy court in Chapter 11. I think schemes have had a pretty good run in terms of long arm jurisdiction. As long as I mean, it used to be that you had to be English incorporated, and then it was enough that you could be wound up in England, and now it's enough if there's English law debt or any sort of touchstone with England and Wales. In terms of creditor classes and voting, again, the cases are showing that for restructuring plans, as long as creditors are placed in classes, and the test is exactly the same pretty much as Mr. Justice Trower confirmed in the Virgin Atlantic case, it's pretty much the same for restructuring plans as for schemes, as long as the rights are not so dissimilar, so that they can vote together with a view to a common purpose. You can put creditors into the same class. But here's the rub. Whereas with schemes, you normally have to either be able to, if you have different classes, all of those classes would have to agree by 75% in value, majority in number. With restructuring plans, if you have one class that agrees and another class that dissents, doesn't agree, the class that agrees can cram down using cross-class cram down, which is a new concept under English law, that dissenting class, as long as you can show that dissenting class are doing better than than they would have done in the relevant alternative. Normally, normally a liquidation, but not necessarily. And you need obviously expert evidence of that. And that's where restructuring plans are in a very similar territory to Chapter 11, although not quite, because for restructuring plans you don't get the moratorium as well. So it's sort of a Chapter 11 light, but it's the financial difficulties and the cross-class cram down that really give it that flavour more of insolvency, of an insolvency process. Just moving on, because I was conscious of time. So what have the cases so far taught us? Well, as I said, the courts are leveraging very significantly off of the scheme jurisdiction. There are key differences. As I said, the conditions of entry and the ability to cram down a dissenting class. In terms of recognition of restructuring plans, this is going to be an interesting debate and topic. Before Brexit, most schemes across Europe would have been recognised under the Brussels regulation or Lugano. After Brexit, I think people are hoping that Lugano that the UK exceeds to Lugano, but if not, there may be other bases for restructuring plans. It's interesting, and there may be a debate to be had as to whether Lugano, I mean, even if we accede to it, could apply, given the insolvency type nature of restructuring plans when compared with schemes, and that's a debate to have. Interestingly, if you look at the Netherlands and talk to Dutch counterparts, they would say that their equivalent, well, it sits in Annex A of the European Insolvency Regulation. So it's definitely an insolvency process, and they would say that's their public process, and their private process is very much has the nature of an insolvency process. So it's going to be interesting to see what happens and how this area develops. Also quite interesting at the moment in the middle of the COVID pandemic, because there's a lot of airlines and airline lessors out there trying to restructure, and if a scheme or restructuring plan is seen to be an insolvency related event for the purposes of the Cape Town Convention or Cape Town regulations, then that would mean that process could not be binding on people to stop them enforcing or their Cape Town interests, security interests, or modifying their rights. That's sort of the law has the cases have not looked at that definitively. Virgin and Malaysia Airlines are two cases where it may have come up, but didn't so far, at least. And Nordic Aviation was another one. So again, that's an interesting debate to be had, and just shows there is there may well be a difference between schemes and restructuring plans in the offing. So Christian asked, well, have these measures worked? Well, I think at the moment it's just too early to say. There hasn't been a wave of formal insolvencies, and there's only been a handful of cases. I think there's maybe 4 cases now, or 3 that have been successful so far. I think there haven't been a wave of formal insolvencies, frankly, because all of the governmental measures that sit there to help businesses are still there. And so most people you talk to will say, look, we're not going to know. First of all, there's going to be a massive wave come the summer for those restructuring lawyers that were hoping to get away for the summer. COVID may be gone. Fingers crossed, but there may be a bit to do at home. So it's probably that rather than the success of restructuring plans or these measures. And it's very difficult to know how you would measure the success here. How many times is it used? Amount of debt restructured, etc., etc. I think when you look at schemes, I mean, they've been hugely successful. So I think we have to wait a few years to test the same metrics for restructuring plans. Equally, how will things change going forward? Sometimes the use of measures or the non-use of measures may not necessarily indicate lack of success. because traditionally, certainly in England, the approach is to reach consensual agreement, and the new restructuring plan may actually encourage consensus. If people realise they, on schemes, the number of schemes I've been involved in where opposition has withdrawn at the last minute, or you've withdrawn the proceeding because people have realised they're going to be crammed down. They're not going to be able to fight sanction, and so to sign up. Equally with restructuring plans, notwithstanding all the touch points around can you cross-class cram down relevant alternative, it's still an expense, it's still a battle, and there's quite a tool there. And I think it will. I think it will potentially swing the balance more to debtors. Because in the sense of having a tool that they can use, like the scheme, but a super scheme now, along the lines of the Dutch equivalent and the coming German equivalent, to help with the restructuring process. And I think and it'll be interesting to see how what creditors do. Will they carry on documenting facilities or documentation under English law? Will it be New York law? And what would the countermeasures be for that? And when you advise debtors on that, in the end, and creditors, in the end, we do have a superb judiciary. I mean, when I talk to my German partners, and they tell me that actually the judiciary for people that will be sitting listening to German schemes will be ex-insolvency practitioners, not judges who have steeped in restructuring laws, who were QCs. That's that's a big difference. We have a very sophisticated bench, of men and women who know what they're doing and have seen it all before. So that's also quite encouraging. Just to finish off, what would I have done differently? I don't know if that was a question to me, although after so many years, I don't know what I'd have done differently. Probably grown my hair. Taken a while. I think. I mean, just looking at moving away from restructuring plans generally, and I think I would have liked a little bit more. I think that the provisions on prohibition on insolvency termination and the moratorium, I haven't really gone into them. They're in the appendix to the slides. I think they're pretty bloody complicated, to be honest. And I mean, the moratorium, at least, I just look at that and think that just looks like a sieve. I mean, who's going to use that? Why would you use that? I mean, others may disagree. In terms of the restructuring plan, the question I've asked myself is it really out of the reach of SMEs? The people that are actually the companies that are being targeted by COVID. It is, it is quite an expensive procedure. It's quite complex. You need experts, and the costs mount up. But there's nothing in the legislation to prevent the process being used for lower value businesses. But I think the courts will have to get very practical as to what they expect. I mean, finally, you've got to remember that these tools are only one part of the UK restructuring regime, and it's always useful to keep in mind that there are other options, other tools in the toolbox. It's certainly a fascinating time. It's certainly quite a nerve-wracking time as a lawyer trying to advise clients, and telling them, when they ask you, well, what's the chance of success, and you say, well, it's 50-50. I don't think I've ever had to say that before. But until the law is more developed on this stuff, I think that's where we are. Christian, that was all I was going to say for now.
Thank you very much, Philip. And when you say 50-50, you mean in relation to the new restructuring plan? Or something?
Yeah, well, if someone's asking you, about jurisdiction, or they're asking you about relevant alternative, how's the judge going to rule? It's like, I don't know. There's no track record. You can give you can put your finger in the air and say, well, look, on the basis of experience, on the basis of other jurisdictions, I would expect. Like someone said to me in a recent case. Well, so if you've got cross-class, if you've got 100 creditors and you've got 2 or 3 with small amounts of debt who agree with you, looking to cram down everyone else, would the judge really, allow cross-class cram down? Now the jurisdiction's there, but whether that's fair as a matter of discretion, I can't believe is the case. But that's not 50-50. I would actually say, I wouldn't have expected cross-class cram down to be used in that instance. But there are lots of shades of grey in between where you think, well, Virgin Atlantic was another one where they had, four classes, 3 classes had all locked up totally, and Mr. Justice Snowden had commented, it wasn't part of the decision, that he wasn't sure whether those 3 classes could cram down necessarily the 4th class, had the 4th class needs to be crammed down, because they had all agreed and locked up. That was dispelled now by Mr. Justice Trower in Deep Ocean, but until then it was like, oh, okay, that's a new point. I hadn't thought about that before. So there's lots of new points in law here, and it's not necessarily unpredictable, but you can't say with any certainty to clients at the moment how things are going to pan out.
Thanks very much, Philip. Super helpful and interesting. So it is the lack of case law, I guess, is what I'm hearing on the interpretation of the key provisions.
At the moment, but then you've got barristers like Felicity, so who provide excellent. I think she's done most of these, so
Yes, indeed. Absolutely. And I will ask Felicity and Sarah whether they have the same reaction to Philip overall to the restructuring reforms, because what I'm hearing from Philip is sort of cautious optimism about the restructuring related permanent reforms and less optimism about the moratorium and the statutory treatment of ipso facto clauses, which are the other 2 substantial reforms, permanent reforms introduced in the same piece of legislation. And thank you very much to the audience members who've posted questions, which we'll also come to in the Q&A. But now we'll hand over to Sarah for her presentation. Thanks, Sarah.
Thanks, Kristen. Let me just see if I can share my screen. Excellent. And just join my fellow speakers in thanking Kristen and all of the team at Oxford for inviting me to speak. I'm delighted to be here. So I thought what I would try to do with my brief period of time is rise to the challenge of what the longer term effects are of the particular suspensions and amendments which Felicity and Philip have talked about, and also perhaps to try to draw out some common themes from their remarks. And what I really want to focus on is whether in the English law toolbox, we are beginning to lose sight of any underlying principles which can produce an element of consistency to our regime. So let me just try and explain what I mean by that. So as we heard from Kristen in her opening remarks, we're really talking about 2 buckets of interventions. The interventions to, as Kristen put it rather nicely, I thought, dilute the direct and indirect triggers for insolvency proceedings. And secondly, as Felicity and Philip have both commented on, permanent and significant changes to pre-pandemic insolvency law. What are the implications of that? Well, they magnify a feature of English corporate insolvency law which existed before these changes, but I think they really magnify it. So the English approach is, I'm going to borrow a term here that Davis, Madhouse and Mazzoni et al. Used in their book on micro and small and medium-sized enterprises. They used a term of modular insolvency law. And I like this term modular because the English process is modular. We have lots of different tools, and we've touched on some of them in the remarks from Philip and Felicity, which can be used on their own or in combination. And that contrasts starkly with Chapter 11, which is largely a single gateway. So you pass through that gateway, and then you can do all sorts of things once you're through the gateway, but you're funneled through 11. Our system's not like that. That means 2 things, and I think this has come out really nicely in the remarks so far. We have remedies which overlap. So for the same cause of action, for the same action, we could proceed under multiple different remedies, all of which are different, some in subtle ways, some in less subtle ways. Secondly, we end up after these changes with a mixture of some old procedures which already overlapped and some new procedures which overlap with the procedures we already have. Now, I'm a great fan of the flexibility of this system. I think I'm a huge fan of it. I think in many ways it is one of the best features of English corporate insolvency law. But it seems to me there does need to be some consistency, some idea of fundamental principles across our regime as a whole. And so the challenge is, are we really now, with this smorgasbord of remedies and procedures, which we keep adding to, we haven't done a consolidation job, a proper review of how the procedures fit together since 1986, for entirely understandable reasons, I have to say. But are we beginning to lose sight of any coherent principles at all? So I'm going to focus, because I think this is really the focus of the panel, post-COVID-19, what we are most likely to want to do is restructure viable businesses. So I'm assuming that we're in a restructuring space. And there are two things that a business that needs to restructure might need to do. The first is it might need to stabilize the business and create liquidity while it thinks about restructuring its liabilities. And then the second is it may need some help in restructuring those liabilities. So starting with stabilizing the business and creating liquidity, this is clearly where the temporary provisions and changing the incentives to resort to insolvency law come in. So the temporary provisions, the temporary suspension of wrongful trading liability, the restrictions on winding up petitions and orders, and other restrictions, including, for example, on landlords' rights of re-entry or forfeiture. Those were clearly all designed to relieve the pressure to seek insolvency law protection by helping businesses to stabilize and create liquidity outside an insolvency process. So a financially distressed business could be stabilized because we restricted creditors' ability to take action, and it created liquidity because it created the environment in which businesses were able to resist paying particular accruing liabilities without suffering the risk of being placed into a process or some sort of action being taken against them. So no immediate need to use insolvency law tools to stabilize the business and create liquidity. And I'm not going to talk about felicities. I think we can explain actually why wrongful trading was a particular candidate here, but I'm going to leave that for the Q&A for later. I think governments around the world broadly focused on this desire to help to stabilize businesses and create liquidity without the use of tools, because we didn't want everybody filing. It would result on too much pressure on the courts, all of the direct and indirect costs that come with an insolvency proceeding. So it was a completely understandable approach, particularly in Europe, actually. Other jurisdictions have not done it to the same extent, but particularly in Europe. But I think what governments perhaps didn't focus on as much, and I think this is also completely understandable in the time we were in, was the distributional consequences of using these procedures. So thinking about Felicity's pyramid, if you like, of different claims, wrongful and fraudulent trading, I'm going to put transaction avoidance in here too, common law duties to creditors, and disqualification and compensation. What has happened during this long period of time, now almost coming up for a year, is that companies have needed to create liquidity and have paid some creditors, and they have not paid others, and over a very long period of time. And so, for example, high-profile comment in the press about the building up of commercial rent arrears, whilst other unsecured creditors have been paid. I don't have time to go into this at all in the brief time that we have for remarks today, but suffice it to say that choosing who to pay and who not to pay, where there would have been a concern, a real concern that you would never be able to meet the unpaid liabilities, falls squarely in the wrongful trading territory following a judgment of Mr. Justice Snowden in a case called Rules Builders. And wrongful trading liability has been suspended, so that would appear not to be an issue during the COVID-19 period. Transaction avoidance, the English law transaction avoidance regime, is famously quite benign if you have a commercial reason for picking who you pay and who you don't pay. But there are other provisions on this list which may come into the frame when the distributional consequences of this long period of trading without any form of insolvency supervision come under the microscope. So when afterwards we see which liabilities built up and were left unpaid and which didn't. And as I say, no real time to develop that here, But Christian and Andrew Kay and others have written compellingly about using the common law duty for those preference-like claims, but which do not fall within our transaction avoidance regime. As Felicity alluded to, we now have a compensation idea tagged onto our disqualification regime. So what used to be a quite straightforward bifurcation between private law remedies in providing compensation and disqualification as a state remedy to take errant directors off the road, that has become very blurred. So we've got these overlapping remedies against a background, I think, of not really giving directors, and this is not a UK issue, I would say it's a European issue, not really giving directors any kind of guiding principles beyond we don't want you to file in terms of what we did want them to do during this period of time. And of course, it has ended up being much longer than anyone, I think, anticipated. So with an eye on the time and speeding up a bit, what about this idea of stabilization? Well, once we see the temporary provisions no longer being extended, and once we see creditors being able to take action against the distressed company, then there may be reason to resort to stabilization tools, both to try to stabilize the business, prevent termination, and also to create liquidity, as some of the things that have helped that to happen fall away. And so we may see companies resorting to those tools, even though we haven't seen it in this period. But again, the distributional consequences in English law have become extremely inconsistent if you resort to these tools. So I'm just going to pick particular examples rather than do a full overview. I'm just going to focus in on 2 examples. So we have 2 different tools that can be used to stabilize the business and create liquidity. One is the Part A1 moratorium, and the other is administration. Administration has not traditionally been used for that purpose, but it can be. It can be adapted for this purpose. However, when we look at the distributional consequences of these 2 procedures, they are now starkly different. And I've just picked a sort of smorgasbord of particular liabilities to illustrate what I mean. So in the Part A1 moratorium, rent does have to be paid for the duration of the moratorium. It appears to be on the whole of the estate. There doesn't seem to be any flexibility around that. And I am assuming for present purposes that rent is paid as you go. Wages and salary need to be paid both for the period before filing for the moratorium and the period after moratorium. And so does loan debt service. So loan debt service, both for the period before the moratorium and the period after the moratorium, has to be paid in full. You can't use the procedure at all in most circumstances if you have bond debt. Now let's compare and contrast that with administration, and we might be using administration for precisely the same purpose, to stabilize the business and create liquidity, but the distributional consequences are completely different. Rent is paid as an expense, but on what's known as the Lundy Granite Principle, so a very old case. Don't have time to go into that now, but I would argue that gives more flexibility than the Part A1 moratorium. Wages and salary are only paid after filing and only on contracts which are adopted, and both bond and loan debt can be suspended. So very difficult to start to discern principles that are dictating what has to be paid and what doesn't have to be paid in 2 tools which can be used for broadly the same purpose. When we come to restructuring liabilities, that actually gets even starker. And again, I could do a sort of full review if we had an entire evening to do this, but again, I'm just going to zone in on a particular example. So we have multiple procedures, as Philip very nicely illustrated, for restructuring liabilities now in our toolbox. And I'm just going to contrast 2, the company voluntary arrangement, which we haven't talked about this evening, which is an existing tool in our toolbox, and the Part 26A restructuring plan, which Philip has talked about. And I'm just going to, again, just laser in on some particular differences. This is in no way complete. The company voluntary arrangement was designed originally as a small company tool. And because of that, it is procedurally very light, and that is deliberate. And if you look at the policy behind it at the time it was implemented, it was procedurally light because the idea was that small companies would be using it. So creditors vote together in a single class. And so what we have seen, but at the same time, there is nothing in the statute which restricts the company voluntary arrangement. solely to small companies. So what we have seen is some very large companies using the company voluntary arrangement to take advantage of single class voting, because both unimpaired or barely impaired and impaired creditors can be put together in the same class. And in some of these company voluntary arrangements, those unimpaired creditors or barely impaired creditors are in effect being used to cram the plan down on impaired creditors within the same class. Secondly, there's no court hearing in a company voluntary arrangement. Again, small company tool, procedurally light, designed to be cheap. So absent a challenge, no court looks at the company voluntary arrangement. Again, major advantage in certain circumstances for a large corporate, avoiding creating a forum in which disgruntled creditors can air their views. And finally, if you do decide to challenge a company voluntary arrangement, you're going to have to fund it. And the challenges to company voluntary arrangements at the larger end of the market are actually pretty expensive. Now, compare and contrast that with the Part 26A restructuring plan if you are using a cross-class cram-down in the way that Philip has discussed. Here we have separate classes, so our unimpaired and our impaired creditors would never be put together in the same class. Secondly, there is always a sanction hearing. So we create a forum at which creditors can express their unhappiness with the plan. But finally, and I think really crucially, the emerging jurisprudence, both from schemes and from the restructuring plan, suggests that you are very unlikely to suffer costs for appearing at sanction if you are performing a function in helping the court to understand, if you like, the opposing view to the plan. So provided you are performing a function in helping the judge to consider whether he should exercise his discretion to sanction, you are very unlikely to suffer costs. And so what we see is a real pick and mix approach to these procedures, with companies choosing the procedure which best fits the type of liability that they are looking to compromise. And so we see cases in which the restructuring plan is used for financial debt, and there are various reasons why you would really have to use the restructuring plan for financial debt. Other companies in the same group turning to the company voluntary arrangement to deal with rental liabilities. So again, difficult really to see guiding principles emerging between these different procedures. What we've ended up with is a modular approach that is highly flexible, but where the incentives are really quite different for the debtor in picking and choosing between the tools. So, of course, the question is, does it matter? I think it is beginning to matter. So, as I say, I am a fan of our flexible approach, and I am a fan of how adaptable it is. And I think that has suited English law extremely well up until now, has served us very well. But I think that as our remedies continue to multiply in this overlapping way, it is becoming quite difficult to navigate what the real principles are. And directors need guiding principles. They need some sort of idea of what the guiding principles that are at work underneath the legislation really are. And I also have a concern about the multiple overlapping procedures and both these different distributional consequences between them and the different impact that they have on bargaining power between different types of creditors. I think I've completely overrun my time, but what would I do about it? Well, in an ideal world, I think we would definitely have another cork. I think it is time to step back and look at the whole of our toolbox and how it fits together. I suspect that is extremely unlikely at the moment. The profession is going to be, I think, fantastically busy, and government has an enormous amount to do as we emerge from all of this. And it is probably not the moment for us to be sitting back and undertaking some deep review of insolvency law. Whilst that would be on my wish list, I'm not sure it's very practical. I would therefore suggest that what we might see is much more read across from the court between different effects in different types of procedures. As Philip said, we've got a highly expert judiciary. Courts only look at the cases before them, and they only look at them in the way that they have been brought. But we have seen the judiciary in other contexts in the past read across to what would have happened if the company had chosen to use a different procedure to deal with the same liability. And I suspect that we will see that happening as we see the COVID-19 cases beginning to emerge, and that may actually begin to bring a little bit more consistency back into the picture.
Thank you so much, Sarah. Absolutely fantastic. So much interesting content. Thank you so much, Sarah. And I too find it difficult to discern a principled reason for some of the differences we observe between the pre-pandemic procedures and the procedures newly introduced. A particular puzzle for me is the treatment of, as I've mentioned to you previously, loan debts in the moratorium. It's a particular puzzle to me why it is that we've ended up with the moratorium designed in the way that it is. So we have 3 questions from audience members, and I'll supplement these with some questions of my own. So thank you so much to all the speakers for really, really interesting, thoughtful presentations. So let's go back to the first set of points that were made about director liability and how directors should have been treated during the pandemic and whether they might have been given more guidance. And I really liked the way Sarah put it, that directors were told what not to do, but less so what they ought to do. So let me begin by asking Sarah and Philip whether they think that there was any value in the wrongful trading suspension. And then each of you might want to respond to what Amir Licht has posted in the chat, which is a follow-on to what Felicity said, a question whether or not the suspension of wrongful trading was primarily a political gesture, is what Amir has asked, in order, perhaps, he says, to be perceived as doing more than nothing. So, Philip, would you like to kick off with your thoughts on the wrongful trading suspension, and then Sarah, and then I'll return to Felicity for her reaction.
Yeah, thanks, Kristen. I mean, I right at the beginning of the pandemic, I mean, the calls we were getting were from companies, directors saying, "What do we do? What do we do now? You know, is it, you know, should we be shutting up shop?" And you know, and then this suspension came out, and everyone was saying, "Oh, that's okay then." And I was saying, "Well, hold on a minute. This is just wrongful trading under the statute. You've still got your common law and equitable duties. You still owe fiduciary duties. So actually, you should just carry on as if, you know, they were still in place." So, I mean, to the question that got asked on the chat, and I just thought it was a bit of a fig leaf, frankly, a political fig leaf. I wasn't really sure what it meant. I'm as bemused as Felicity is about how it kind of, there was a bit of a gap. So a bit like, you know, mind the gap when you get on the tube sort of thing. Okay, so now you're okay, now you're not, now you're okay again. It just doesn't make any sense.
Sarah? Thanks.
I'm going to be a bit more generous, I think. I think that at the large end of the market, well-advised companies are perfectly used to navigating the wrongful trading regime. I'm not sure that that is as true. In fact, I'm quite sure it isn't as true at the smaller end of the market, where perhaps there is less specialist insolvency advice, and navigating duties, I think, doesn't always happen in quite the way that it happens at the larger end of the market. And so I think a lot of SME directors were particularly anxious about wrongful trading liability. And I think there is a difference, and this is the difference. As Felicity has said, wrongful trading is a mixture of an objective and a subjective test. And so a particular concern with how you framed your objective view of surviving the insolvency when you really had no idea. And as I say, at the larger end of the market, I think we all knew how to navigate that. But I think it was causing concern at the smaller end of the market. The difference with the common law duties is that the common law duties, provided you turn your attention to the creditors, at least the common law duties are subjective. They are what the director, not what the court thinks was in the best interest of the company. And that is, I think, a distinction between the common law duties and the wrongful trading duties. One of the reasons that it's very hard to bring a claim under the common law duty, because provided the director can show he turned his mind to the question, it's really quite hard to challenge what he did. And effectively, we're really thinking about bad faith. So I think I can see a distinction. I think I can also understand why in September it looked like we didn't need to renew it, but then the landscape was obviously changing again. And the problem with not renewing something is, what signal does that send? I think at the larger end of the market, again, that would have been understood as everyone deciding that it was all navigable anyway. But I'm not quite sure what signal it would have sent at the smaller and the medium-sized end of the market. Does this now mean that we've got to worry more than we did in September? And of course, this was a hugely anxious and difficult time for directors. So I think I can see a rationale. I think, as I say, that it's more of an SME concern perhaps than at the larger end of the market. And I think I can see why you might have thought it could run off, but then worry about that as the landscape changed again.
Thank you, Sarah. Felicity, would you like to add anything else to this discussion?
Yeah, I mean, that's a very generous way, I think, of viewing what the government might have been thinking. There's no indication of that in any of the explanatory notes or any of the consultations. In fact, there was nothing really in any of the consultations about it, because it just was made up on the spot. My concern is that, having dealt with people who are directors of SMEs, they usually find it quite difficult to tell the distinction between wrongful trading and other things. And so once you say to them, I'm suspending wrongful trading, they immediately think, oh, well, I can do whatever I like. And similarly, if you say to them, and I think there is something in what you say, Sarah, that if you say to them, oh, there are risks of wrongful trading, they then worry about everything. So they view it as a unitary thing. They don't view it as a difference between subjective and objective. Plus, there's the oddity, of course, of a 212 claim, a misfeasance claim, also including negligence. And then there's the question of how wide the defence of honest and reasonable action goes. Is that partly subjective, or is it actually partly objective? So I'm not sure I could actually divide them into a subjective and an objective one, nor do I think at the SME level that's what directors do. I mean, I remember a misfeasance claim I had against a director who had signed blank checks and then handed it over to his other director, who then stole money from the company. And while I was cross-examining him, he said, I said to him, well, why did you have two signatures on the checks in the first place? And he said, well, I didn't trust him. So I thought it was really important that we should have two signatures. And I said, well, then you just signed it and handed it over to him. And he said, well, it wasn't misfeasance, it was just negligence. And I was like, okay, this is the point where you probably should not be being cross-examined by me. But I think that there isn't an understanding at an SME level. I think where there is an understanding is at the level that Philip's advising, which is the more sophisticated, bigger entities. So I don't really understand it, and I certainly don't understand the gap. And I don't understand why they didn't extend it and then they did extend it. There was really no discussion around it. It was very odd that it just sort of kept coming out and then going away. Lots of discussions about all sorts of other things. So going back to Amir's question, do I think it was a public relations exercise, or as Philip put it, a fig leaf? That's certainly a possibility. But if it was, it wasn't a very good one, because it didn't really hit all the targets it needed to hit.
Thank you very much, Felicity. I mean, my own reaction to this question is that the best explanation I can come up with for the suspension, or so-called suspension, of the wrongful trading rule is misunderstanding about what that rule is and what it requires, because that rule is often reported in the press as a rule which makes it, for example, and this was a description that appeared in the FT shortly after the first lockdown, the rule is often described as a rule that makes it criminal for directors to continue to trade while insolvent. Of course, this bears almost no relationship to the actual rule, but if this were thought to be the rule, then I could see value in suspending it. The risk of this, and this again betrays the complexity and piecemeal nature of English law, English insolvency law, is that in so doing, and in the way that it was done, you might send a signal to directors that they enjoy more protection than they actually do. And we shall have to see whether or not there is evidence of directors taking liberties they might not have taken. absent the announcement of the suspension. But as you said, Felicity, in your presentation, all of this very much depends on who in the real world is in fact influenced by these rules. And this is something on which scholars and practitioners disagree. There's a comment from Hamish Anderson. Thank you, Hamish, in the chat. Hamish asks whether putting all of this together, we ever would have actually enacted the wrongful trading rule had we known we were going to end up with this other body of rules which complements the wrongful trading rule. And I think it's a very important question. I can see Sarah nodding. Would you like to comment on that, Sarah, before we turn to restructuring plans?
Yes, I think that's an excellent intervention. When you look at the options around the world, very few jurisdictions have both something in this sort of space, so some sort of duty to file. Of course, ours falls much shorter of a duty to file, but both that and a general duty shift. So having both of those is extremely unusual. And where you do see it, it's generally other sort of Commonwealth jurisdictions. And I think that they sit increasingly uneasily together. The distributional bit that I talked about is just one example, but actually I think there are a number of ways in which they don't sit very easily together.
Thank you, Sarah. And yeah, I mean, Inga West has also posted something in the Q&A. Thank you, Inga, picking up on this same idea about whether or not, having regard to these multiple overlapping but not entirely consistent rules, we need to think about consolidating our approach to directors' liability. I mean, Hamish, I agree. I think it's interesting to note that the wrongful trading rule arrives at about the same time as the duty shifting rule, and the creditor regarding duty shifting rule. And it's also much harder for Parliament to temporarily, in my view, suspend the creditor regarding duty shifting rule. It's a more complex rule, it's a judge-made rule, and it's also multifaceted in that it affects not only what directors can do, but also what shareholders can do and what is within the scope of ratification. So that's a mighty hard thing to deal with with emergency rulemaking in the midst of a pandemic. Now, Philip, I know you have to drop off soon. So before you go, I would just like to ask you a couple of things about the restructuring material you presented, picking up on some of the comments in the chat. So Lucy has asked, Lucy McCann, whether you think there's one particular sector that will benefit from the restructuring plan. And then we also have a question asking whether or not, in the view of the panelists, the government has done enough to support SME restructuring. So Philip, before you go, I wondered if you'd like to answer both of those questions, and then I'll ask Felicity and Sarah for their comments.
Hang on for a little bit. I think actually they're very similar sides to the same coin. Or I mean, you can answer the both questions in the same way. And what do I mean by that? I mean that I don't think there's any one sector that would benefit or not from restructuring plans. I think it's a question of looking at the size of the company and the capital structure, and where you've got a more complex capital structure, those companies would definitely benefit more from a restructuring plan, because they can use cross-class cram down. If you have your creditors in different classes, you can get a restructuring through in a way which is easier than getting everyone's consent, and that generally tends, not always, but generally tends to be the larger companies. So therefore, to the second question about SMEs, I'm just not sure that restructuring plans are a panacea for them, because because of their capital structures will probably be a lot more simple, and maybe they'll be more into schemes, but maybe not even schemes, because these are expensive procedures. There are 2 court hearings, there's substantial documentation, quite complex legal issues to be determined. And it's not every finance director or general counsel of a smaller company, if they've got one, or a general counsel, I mean, who's going to want to spend that sort of money. And it could be it's hundreds of thousands of pounds. So I think, therefore, no one sector particularly, but the larger companies. And I think, yes, to the question, which was are these suitable for SMEs? I think that's one of the points I picked up on. I'm not sure, and I'm not sure they're going to be used so much.
Thank you, Philip. Felicity, would you like to comment on whether the government's done enough to support SME restructuring?
No, I mean, the oddity about that is that we had the small CVA moratorium, and everyone thought that was the answer. because nobody thought it was schemes, and certainly nobody thought it was restructuring plans, which were a glint in the eye. And I remember giving a talk at which I said, England will never introduce cross-class cram-down. I think that was at the same talk I said there's never going to be a ban on ipso facto clauses. So I feel like I've, hit the jackpot twice on this. But the idea was that these small CVAs with a moratorium would be used, and they've basically not been used. Well, I don't know of any. I mean, I think anecdotally there might have been one, but I'm not sure that's real. It might just be an urban myth. And it's the same problem in relation to the moratorium. The idea was the moratorium would be used as a cheap, quick debtor in possession process for SMEs. I don't think it's going to be used like that. So certainly I would absolutely agree with Philip. I mean, particularly in relation to the restructuring plans I'm doing. I mean, they are just huge, mammoth things, even straightforward ones. But with RPs, as Philip says, there's just question after question after question, even the ones that were answered the same, have the same wording in the context of schemes, and you think you know the answer. RPs are different. I mean, they have all sorts of different things. So you can't be sure you know the answer, even where you think the answer is, oh, it's just like a scheme.
Thank you, Felicity. Sarah, would you like to add anything on this point? And then there's also a question from Professor Payne in the chat on valuation, and I thought you might like to pick up on that at the same time, Sarah. So the question from Jenny is, how easy will it be for courts to determine the very difficult questions of valuation that they'll have to apply the new restructuring plan procedure? And should Parliament have given courts more guidance on this question? Thanks, Sarah.
Thanks, Kristen. So on the SME restructuring, I'm shaping up, like all academics, to be the contrarian on the panel, I think. So I am more optimistic about developing the restructuring plan as a small company tool, although I think that is going to lie in the hands of the court. So let's just park that for one moment. I mean, small companies have benefited hugely from being able to use connected party prepackaged administration functionally to achieve a restructuring. And that has huge advantages for small companies. Notably, it really reduces the number of people you need to negotiate with. So you can negotiate with your bank, you can negotiate with the creditors that need to be on side. But other than that, it's largely non-negotiated. And that, when you look around the world, that's a real feature of successful small company procedures, because nobody's got the money to negotiate. And I think that's really why we don't see the company voluntary arrangement being used, because we need the 75% threshold with a large number of very small creditors, many of whom struggle to come to terms with their economic loss. That's actually a very high threshold. And so the connected party prepack has really found its home. Now, of course, that is under some significant pressure. It's under government pressure. It's also under public pressure and public scrutiny. And the question is, could the restructuring plan sit midway between those two procedures? So could it reduce the need to negotiate with a very large group because it offers the possibility of cross-class cram-down? So it offers a non-negotiated route, whilst dealing with some of the legitimacy challenges with the connected party prepack, which might affect your ability to get going on the other side. And can it find a home? Now, I think it can. So again, I said I was going to be the contrarian here. I think it can find a home. I think there is a bit of a model for it with the Small Business Reorganization Act in the US, which has made some pretty significant changes to Chapter 11 for small businesses, many of which we could replicate in the restructuring plan. And there isn't really time to go through that now, but I think there is a route for the court, if the court is open to this, to reduce the disclosure requirements, some evidence from the Sunbird scheme of arrangement that they're already alive to that, but also to think about how, for example, the leave to convene hearing operates much more as the judge talking through with the company what the plan is, rather than a leave to convene in the large company space. And what we lose in the cost of the court, we may gain in the benefit of reducing negotiation costs. And so no time to expand that idea more, but I would say I am more optimistic that it's adaptable, but I think it will be left to the judges to adapt it. In answer to the question, I don't think there was time to do all of those adaptations on top of everything else that was being done. But because it's a very thin statutory scheme, there is plenty of latitude there for the courts to develop it. And we'll have to see both whether there's a willingness to use it, and that will depend on people losing their affinity for the connected party prepackaged administration as a solution. So will there be demand? And if there is demand, will the courts adapt it? So that's the answer to, I think, my response to that part of the question. On valuation, so as Professor Payne knows, as many participants know, I'm fascinated by this topic. And in some ways, I think that the legislation has given a very clear steer, and in another way, it is more difficult. Where the legislation has given a very clear steer is where the company goes into the restructuring process, where it is tolerably clear that what will happen, absent sanction of the restructuring, is some sort of administration process, insolvency process. So a sale of the business and assets. If the restructuring can't be achieved, you're going to have to move down the hierarchy of options to either sell the business and assets as a going concern or sell the assets on a breakup basis. And by using the relevant alternative, in that world, it's relatively clear that the method of valuation is market price, rather than some sort of search for the intrinsic value of the company, because that would be the relevant alternative. And the really difficult valuation question, I would suggest, is between whether you focus on market price, what somebody would be willing to pay for the business in current market conditions, or the intrinsic value of the business, what would you get for the business in general, sort of normalized, if you like, market terms. And so I think that value, I think there is a fairly clear indication that it's market price. And I think that is something that the courts will be able to navigate relatively easily. The much more difficult question, I think, is actually not the valuation question per se, but the debate over what the relevant alternative would be. And we haven't seen that debate yet, because all of the cases that have come before the court so far, there's been broad agreement about what that relevant alternative looks like. But that won't always be the case. There will be cases where there's genuine debate over what the relevant alternative is. And then you have to move from that to what valuation does that then implicate? And so I think that has got a way to go.
Thank you very much, Sarah, for that answer. Again, super helpful. So I'm conscious that we have 2 minutes to go on the clock. I'm sorry we can't answer all the questions that have been put to us in the Q&A. On the SME point, which I think is a great question, I too, and other audience members also had the same reaction as Sarah did, thought immediately of the connected party pre-pack. And it's Sarah who wrote about this several years ago to explain how connected party pre-packs are used in this jurisdiction as a functionally equivalent to a reorganization, but without negotiation with those out of the money. And there's some indication in the explanatory materials associated with this law reform that the government expects that the new moratorium might do something of what prepackaged connected party sales used to do. And I just don't think that's possible on the design of the new moratorium. So I can see Sarah's point that we might be able to use the new restructuring plan, at least for medium-sized businesses. But I think at the micro end of the market, we will very much still have to use some form of administration sale unless that becomes unlawful. So I'd like to put a final question to each of the panelists before we go for a 10-second answer from each. So we've talked a lot about rescuing viable businesses and restructuring today. At the same time, there's been a lot of talk in the financial press about how government support during COVID-19 may be enabling unviable businesses to stay alive for too long, and that we might, witness an avalanche of zombies on our horizon very soon. So I wanted to ask each panelist, beginning with Felicity, what they make of these accounts in the press and whether that is a problem in their view for this jurisdiction.
We already have a huge army of zombies out there. We've had them because the banks don't want to take them onto their balance sheets. So they've been rolling and rolling and rolling. And we've seen amend and extend schemes. We will see them in RPs. We've seen variations of that for years and years and years. I absolutely do think there's going to be a tsunami in Q2. And with a combination of those who've been kept alive by furloughing and the effect of the pandemic. But I don't think that is really necessarily the fault of even the temporary suspension. I think it's what happens if you combine a huge pandemic with Brexit. you were always going to have this as a problem. So sorry, more than 10 seconds.
Fantastic. Thanks, Felicity. Philip.
Totally agree. When we started the pandemic, everyone was talking about, is it a U, is it a V, is it a long L, Nike tick, and actually people still don't know. So I don't see how you can restructure something and know what the sustainable debt is unless you know what the recovery curve looks like. I haven't got a clue.
Thank you, Philip. Sarah.
So I agree as well. I mean, I'm not sure what else you could do. And I totally echo what Philip said. You can't really restructure until you've got to the end and you know what it is you need to restructure. There are some businesses that have been able to, but the majority of businesses are going to have to get to some sort of steady state normal before they can work out what they need to write down. But I'm optimistic that at that point we can deal with the zombie problem because, and here I'm going to now be contrarian with myself, but actually our modular approach does give us all of these different tools. And many of them are a really light touch between a full court process and some sort of procedure which you can use to deal with the holdouts and to deal with your non-negotiated group at the end. And as Philip said in his remarks and Felicity's alluded to, they've been shown to be hugely effective. So I think we have the right tools to either actually restructure or to create the bargaining environment, as Philip said, in which parties agree to restructure. So I'm optimistic that we'll be able to deal with it when we get there.
Thank you, Sarah. Well, thank you so much to each of our panelists today for really fantastic presentations and discussion. Thank you for cutting through a lot of complexity to give us a really clear account of what's happened and what you think about it. And yes, hindsight, as alluded to by Sarah, is a wonderful thing, and it's easy for us, in a sense, to be doing this, but it's also important for the reasons that you've given. So thank you very much for all the time you invested in preparing for today, and thank you to the audience members for fantastic questions. Okay, thank you very much, everybody. Bye.